products, dangerous drugs, car crash cases, injuries, and abuse. Across the state of Alabama, the attorneys of Hollis, Wright & Couch are here to serve you. With civil trial lawyer Josh Wright from the firm of Hollis, Wright & Couch and Alabama's 13 host David Lamb. The attorneys answer your tough legal questions straight ahead.
Hello and welcome into the attorneys. I'm David Lamb. Thanks so much for being with us tonight. The whole purpose of this show is to get your tough legal questions answered. This show is a service to you. That's why all throughout the program you will see information for you to get in touch with us. And you can do so now. You can call, text, or email us. We are waiting to answer your questions and put them before our panel of experts. And we're joined once again by Josh Wright from the firm Hollis, Wright & Couch. Good to see you, sir.
You too. Hope you had a good week.
Indeed did. Our topic tonight, so often the topics that we discuss, they're in the news and they're headlines. So often, so many messes in families have to do with the lack of a will, don't they?
Well, that's exactly right. And today's topic is a great topic that impacts really all walks of life. Whether you need a will, what happens if you die without a will, what estate work should be done to eliminate problems at someone's death. All those things are going to be discussed today, and we're real excited about this topic. When we have issues like this at our firm, among other places, we go to Christian & Small here in town. Stephen Benefield is a partner with Christian & Small. Does a fabulous job, handles wills and estates, and oftentimes he is the guy that we go to when we have questions about our clients. So we thought, who better to bring on to talk about these issues than Stephen himself.
Stephen, good to see you. Thanks for being with us.
Thank you, David. Glad to be here.
Well, let's kind of start with an overview and kind of start from the basics and build a foundation and work from there. How do I know if I need a will?
Well, if you have property, or if you have children, or if you have anything that you need to take care of after you think you will be dead, you need a will. Now, as a practical matter, if you don't have anything to leave or anybody you care about, don't bother.
I think most of us,
pretty simple.
I think most of us qualify this.
But particularly for couples who have children or single parents who have children, it is very important to have a will in order to name someone to take care of your children after you are gone. It's important to manage whatever assets that you have, and by using a well-drafted will that has good provisions about powers and enables your personal representative to handle things efficiently, you can save your estate money. In other words, you can give more money to your children, give more money to your heirs, and it won't be eaten up in attorney's fees and court costs or taxes.
Yeah, you really do, and even just this past week, there was the family of someone who was influential and had quite a bit, and the kids are squabbling over what was left because it was not really just laid out well in the will. And I think so often we think, well, if you have gobs of money, you've got to protect it, and wills are for those. Are those some of the excuses and the reasons that folks still do not have wills?
I think that's probably true, and I think what Stephen would say, though, is that having a will is one means to try and protect against those squabbles and those fights after your death. But having a will is not good enough in and of itself. You've got to have a will that's drafted by somebody who knows what they're doing to make sure that they're drafting it in such a way that they can eliminate a lot of these squabbles. And some of them, I guess, you're not going to eliminate no matter what. But if you draft it correctly with the intent of the parties and context involved as to the family before you draft, seems to me that's the easiest way to try and eliminate some of those problems.
It certainly is, Josh. We can't eliminate all conflict because, of course, families have conflict while they're alive.
I've heard that.
Unfortunately, there is no more vicious animal than a beneficiary. And when someone dies, as you can expect, people are upset, people are in mourning, they're grieving, they're hurting, and it makes it all the more difficult to come to reasonable decisions. So having a clearly drafted will or a trust or an estate plan can be a great gift to your family.
Right. Yeah.
Because it settles things. It leaves the questions out of the way. It gets people to where they need to be faster. When you leave property under a well-drafted will or trust, the people have the certainty of knowing what they're getting.
Right.
We can't eliminate the conflict that exists before people die.
Yeah.
And it would be foolish to think that we might. But before you die, one of the greatest gifts that you can give your wife, your husband, your children, your parents, is to collect your assets, to work with an attorney to go through a thorough estate planning process, and to put your affairs in order. You can imagine the difficulty that widows and widowers and children have trying to sort out a mess after somebody has died.
And if you die without a will, David, the state law dictates where the money goes, who gets it, and that happens all too often in Alabama. So having a will properly drafted, well crafted by somebody who knows what they're doing is critically important.
Well, that would take all the power completely out of the family. Someone else, individual. We love getting your questions. Again, that information is on the screen. Ways for you to get that to us, and they will pass those along to us. A question that I've gotten here. I was told that I cannot assign my property to whoever I wanted to by making a will. Is that true?
No.
No? Yeah.
The short answer is no. There are a few limitations, very few limitations, on what you can do with your own property when you die. Now, the law steps in when you start to make strings and you want to try to control the property from the grave. You can't do things such as say, I'm going to leave it to Mary unless she marries Jack. And the law doesn't recognize that kind of impediment to the descent of property. But for the most part, you can leave property in any way you want. In fact, most people don't have any idea of the variety of property interest that can be conveyed and the way they can be conveyed. A trust is an instrument where you set up property with a trustee who holds it for the benefit of someone else. And particularly when you're dealing with minors or people who have infirmities or special needs, it's very important to have a trustee who's going to hold that property for them. That's one of the ways you leave property and you take care of the people you love, is by creating a trust and naming someone who cares about those people as the trustee. It doesn't have to be a bank or a trust company. It can be. And if there's enough money involved, it makes sense that it should be. Because a trustee, like the personal representative in an estate, is a fiduciary. And fiduciaries carry the highest duty that the law imposes. Consequently, they have a lot of hoops, if you want to call them that, to jump through. They have things that they have to do to make sure that they show the people they're taking care of that they're doing so properly.
And Stephen understands the politics of family, and that's why he meets with these folks in advance to figure out who the children are, what issues the family has, to try and craft a will and estate that makes sense.
Love the questions, some real life scenarios in the questions that we've got. This one here, I was left my mother's house in her will. Can I now sell the house now, or is there something else I have to do before I can sell it?
Well, the first thing you have to do is to probate the will. Now, as a practical matter, and all lawyers answer questions this way, and the first answer is, it depends.
That's right.
You know, it always depends on the facts and the circumstances of the case. You know, this lady's been left the house by her mother. Well, does the lady have any brothers or sisters? Is the father still living? Did the mother remarry? See, there are a lot of facts that we would need to know in order to answer the question about who might be entitled to it absent the will. But where you have a will, it removes the questions, and all she has to do is then produce the will to the probate court through her lawyer, have the will probated, in other words, admitted to probate as it's called, and then it becomes law.
Okay. All right. The name of the show is The Attorneys, but when we come back from commercial, we're going to become Family Feud because we have three sisters who do not agree about where we're going to see if Josh and Stephen can help them out. We'll do so right after the break. As we head to break, a reminder, we'd love to hear from you. Get your questions to us. Call, text, or email them to us. Also, you can find the firm on Facebook. Just search for Hollis, Wright & Couch, as well as on Twitter. That is Hollis_Wright. We settle a family feud, we hope, after the break. Stay with us.
I'm Josh Wright with the law firm of Hollis, Wright & Couch, and thanks for watching The Attorneys on Alabama's 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other civil legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family. Or simply contact us by going to alabamas13.com and click on the Attorneys link. We know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on Alabama's 13.
Yeah, you need to know where that will is stored. Important information talking about wills and trusts tonight. This one has stirred up quite a bit of interest, but still time to get your question into us. Call, text, or email that information right there on your screen. We certainly try to make it easy. Gentlemen, a question. This is from a family, and it sounds as though there's some disagreement here. The question from a viewer. I have three sisters. My oldest sister was named as personal representative after my mother died. The rest of us don't feel that she is doing her job as far as handling my mother's property. Can we have her removed?
Perhaps.
Perhaps.
Good lawyer answer.
That good lawyer answer is always, it depends.
Right.
As a practical matter, once someone is appointed as a personal representative, it is very difficult to have them removed unless you can show that they are doing something they should not do.
Okay.
Now, if there is a severe conflict of interest and the other siblings believe that the oldest sister is acting in a way that favors herself over the others, then the court might well remove her and appoint an independent personal representative. But I would suggest caution here. The best thing that families can do in that kind of situation is to communicate. The personal representative, the oldest child, should communicate with the children who are not in control, who are not administering things, so that they know what's going on. And shouldn't think that just because they want to know what's going on, that they're somehow questioning her authority or suggesting that she's doing something wrong. At the same time, the other three need to recognize that they're not the ones who are in charge. They are entitled to an accounting and to hold their sister to an account, but there's no reason to be ugly about it. And you shouldn't assume something is wrong just because you don't know, and that is a very common occurrence. It's just human nature, because people think the worst of what's going on.
You know, and a lot of times, David, when we come to Stephen and his firm, it's because there has been a communication breakdown with the family, and a lot of times for us it revolves around a suit that's been filed on behalf of somebody, albeit a wrongful death suit or a personal injury suit. Communication is so critically important in making sure that all parties are kind of aligned and on the same page about what the direction is. And seems to me that a lot of these will and estate issues get sidetracked because of lack of communication among family.
Okay. Another question that we have: my mother died but did not have a will. I have 5 brothers and sisters. What happens to my mother's house and other property?
Okay. Well, when you die without a will, the state, through the Alabama Code, has sort of made a will for you. It's called the Statute of Descent and Distribution. And it provides for the portion that goes to a spouse, if you have a spouse, and it provides for the portion that goes to everybody else. If you're married, then the spouse's portion depends upon who else is alive. Okay? If you have children from the same marriage, and only children from the same marriage, then the spouse gets a certain amount, and the children and the spouse split a certain amount. Okay. If you have no children, and the parents of the deceased are dead, then the spouse gets everything. Right? If you have children from a prior marriage, then the spouse gets half and the children from the prior marriage split half. So it depends on who else is alive. Now, if there's no spouse, it descends, as you might expect, to your lineal heirs, as they are called. If you have children, it goes to your children. If you have grandchildren and one of your children has died, then it would go to that grandchild by representation. And that's the way the property, quote, descends to the lower generations. At the same time, if you don't have children and you die, it goes back to your parents. Well, if your parents aren't living, then it comes down to your siblings and the descendants of your parents. Well, if there aren't any of those, it goes all the way back to the descendants of your grandparents.
Wow.
So that's when you get out into people that you've never even met and don't know where they are.
Right.
Some folks we call laughing heirs because they're laughing all the way to the bank. They don't know who this was, but they're delighted to have the money.
I'm sure.
You know, so often in these circumstances in the law, the law gives gap fillers. And what we're talking about right now is a perfect example of a gap filler. It is, if you don't spend the time on the front end to get a will together and an estate plan together, the law does provide a filler for that gap. They direct where the money goes, but it takes all the control out of the hands of the person who ultimately has the control to make the decision on where they want their assets and resources to go and who they want them to go to. And so again, another great shining example of, although the law will fix some problems, you want to make sure you do your best to try and get this estate plan together before you absolutely have to have it. Right.
That's a great point, Josh. And you know, another thing that the law provides in an effort to protect people and their inheritances is the accounting and the bonding requirements and the court supervision of the personal representative when you don't have a will. Those are good things because the state doesn't have any way of knowing who the personal representative might be or whether they're honest or good or anything like that. But if you trust the person that you want to name as your personal representative, the person who's going to administer your estate, if you're going to leave it to your spouse, it might be spicy, but you leave it to your spouse. If you leave it to your spouse and your spouse is going to get everything, why would your spouse need to be bonded or need to file an accounting or need to prepare an inventory? That's just additional needless work and expense.
Right.
That's right.
So a will can avoid that needless expense.
Preserve assets.
And preserve assets for the people you love.
All right. A lot of folks do good with their money while they are here. A question here from someone who wants to know about doing good with their money after they're gone. What if I would like to include gifts to charity or my church in my will?
It's a great question, and you definitely have the option to do that. Go ahead, Stephen. I'm sorry.
You sure do. No, that's you can do it in any number of ways. You can leave it to a charity directly. You can leave it to the community foundation. You can leave it to your church. You can leave it in a trust. You can leave it any number of ways to the charity or for the charity's benefit. Now, one of the great ways to make a charitable contribution in a very tax-efficient way is to make the charity the beneficiary of your IRA. That way, the charity doesn't have to pay the income tax on the IRA.
What about 401ks? Is that also included, or is it just the IRAs?
401ks would be the same way. Any kind of qualified retirement plan through your employer, or that maybe you've rolled over into an IRA, is going to be subject to income tax, unless, of course, it's a Roth IRA. And whoever takes that money out is going to have to pay tax on that at the ordinary income tax rate.
Okay. All right.
But if you put it in, just again to add context, if you put it into an estate plan to give to charity, the charity does not have to pay that estate tax. Or pay that tax rather, and so that's a good thing.
Okay. We love grandparents, right? We all love grandparents.
Yep.
After the break, a question from a grandparent thinking ahead and what to do with a grandchild that's 2. So we're thinking way ahead. We'll get to that question whenever the final segment. We come back for the final segment of The Attorneys. A reminder, as we do head to break, call, text, email. Also find the firm of Hollis, Wright & Couch on Facebook. Just search that, Hollis, Wright & Couch. Find them on Twitter as well, Hollis_Wright. Our question from a grandparent after the break.
From all of us at Hollis, Wright & Couch, we're proud to team up with Alabama's 13 to present The Attorneys each Sunday night. Our goal? To answer your tough questions and provide legal support when you need it most. Remember, you can call, text, or email us your legal questions anytime. This week's topic relates to wills and estates. Here are the facts you need to know. It is very important to have a will. A person who dies with a will is said to have died testate, meaning your will actually directs where your assets and property go. But a person who dies without a will is said to have died intestate, and state law will dictate where your assets and other property go. If you die without a will in place, Alabama law takes over. It requires that your assets and property are passed to your heirs. It also states what proportion of your assets go to each person. This means you'll have less control over what happens. That's why a will is so important. Estate planning includes 2 crucial parts: a durable power of attorney and a will. The power of attorney is used if you become incapable of making decisions for yourself. The will directs where your property will go and how your bills will be paid. After drafting a will, let a trusted family member know about it. Educate them about your assets and liabilities, and let them know where you keep your will and other estate paperwork. If you have an idea for our next show topic, let us know. Please remember, your call, email, or text to The Attorneys is free. All of us at Hollis, Wright & Couch want to help answer your questions on real issues you face. We can't guarantee we'll answer every question during the show, but we can guarantee a competent lawyer will respond to every question you send in. Thanks for watching The Attorneys on Alabama's 13.
Welcome back into our final segment of The Attorneys. Let's quickly get right to a question from a grandparent here, gentlemen. I want to leave my grandchild, who's now 2, something in my will. Can I instruct that he only gets the money after he reaches a certain age? And how do I make sure the money is not spent before he reaches 21?
Great question.
Yeah, the short answer is the best thing to do is to leave it in trust for the grandchild. I never, ever want to leave any property to a minor, someone who is not of legal age, or to anyone with special needs, without putting it in trust so that someone can manage that property and take care of it. It's terribly important that the property is not left just to the child, because the child can't legally do anything with it.
Right.
And then you've tied that asset up for a long time, or the parents have to go have a conservator appointed by the court for that child so that legal title can be managed.
Another reason why you go to a guy like Stephen at Christian and Small. We have talked a lot about wills, but a proper estate plan also includes some other documents and things, does it not?
Absolutely, Josh. Estate planning is not just getting a will. Estate planning is exactly what it talks about. It's collecting information, it's processing that information, it's turning that information into a document in a will that will then let that property, after you die, accomplish what you want it to accomplish. The important things are that you plan for your life while you're still alive, that you plan for what happens to your stuff after you die, and that you make things as easy as possible for the people you love. 2 other documents are critical to that process. One is a durable power of attorney, that you give to someone that you absolutely trust, because that durable power of attorney, if it's a general power, will allow that person to do anything that you can do. And that's a lot of power. Mm-hmm. So we have a new power of attorney statute in this state that just took effect January the 1st of this year. If you've got a power of attorney that was executed before this year, you probably ought to get it reviewed.
Right. All right. 1 minute left in the show. Final thoughts from you, Stephen?
The final thought is another essential document is the Advance Directive for Health Care to make end-of-life decisions.
All right.
You really need to do that. The best thing you can do for your family, for the people you love, and to maximize the efficiency of what you want to leave is to engage in a good planning process to get good documents.
Do the planning and do it now.
Stephen Benefield, Christian Small, thank you so much for coming on.
My pleasure.
You have, I will guarantee, answered a lot of questions tonight that people are thinking about, and if they need help, they need to get to somebody early.
Yeah, absolutely. All right, a topic tonight that I think affected a whole lot of folks. Appreciate all the feedback from you all. Stephen and Josh, good to see the both of you. Thank you so much. We'll be back here next week. But a reminder as we wrap up the show this week, you can call, text, email that information and your questions to us for next week's show. Love to hear from you and get your feedback. You can find the firm there as well. Find the firm on Facebook, search Hollis, Wright & Couch, and on Twitter, Hollis_Wright. We appreciate you being with us. We'll see you next week, folks.